I'm recording
Are
as
you going to record? Okay. Okay. Good deal. All right. This presentation's about a dozen cases that involve Louisville before the U.S. Supreme Court. Cases out of Louisville. And I'll start off by saying it was really, really tough to get it down to 12 cases. There are some really fascinating cases out there. I may end up doing a volume 2 at some point because it was difficult. It was enjoyable, but a struggle. This is the U.S. Supreme Court building, and having walked up those steps once, it's scary, as you can well imagine. And I wasn't, at that point, I was not presenting a case. I was just going to sit in the gallery for a case that my agency was working on. But I enjoyed it, but I was glad I wasn't the one standing in front of the justices at that point. Starting off, a lot of folks don't understand how cases get to the Supreme Court. A lot of Kentucky cases have gone up both through the state system and through the federal system, but the Supreme Court has the ability to choose its own cases. And on an average, maybe 12,000 cases are presented to the justices for consideration. On average, they'll take 80 or 90 cases. They try to pick cases that they believe are well crafted and are going to illustrate the point that they wish to address. And in fact, every case has what's called the question presented, where they actually give you, this is what we're going to decide in this case. This is the question that is before us. So I've selected a dozen for this one, cases I thought were both interesting and presented an interesting national issue as well. Kicking off, we are going to start with cases that fall under civil rights. Kentucky has a long history and Louisville has a long history in that. And these look to be cases that I felt everyone might find interesting and educational. Starting off was an 1851 case. 10 years before the outbreak of the Civil War, talking about a case that would have happened the actual incident would have been 1849, 1850. The court agreed that several men who were enslaved, who were owned by Dr. Graham, he allowed them to go back and forth between Ohio and Indiana. They were actually musicians. And I'm presuming he was hiring them out for events and concerts and such. And these men traveled on their own. They were, given their fare and sent off to do what they were tasked with doing. And then he expected them to return to Kentucky. Well, they were traveling in free states at the time. One of these trips, they decided we're not coming back. Can't really blame them on that. They did not return. They had caught a ride on a steamboat owned by Strader. Excuse me, and I realized I got a mistake on the slide there. It is Jacob Strader. Strader owned the boat, and Graham sued him for the loss of the 3 men. Who won? Probably doesn't surprise you to learn that Dr. Graham won. If you know your history in this area, you will know that this same issue was dealt with some years later in Dred Scott versus Sanford. If you read the Scott decision, they're going to reference back to the Strader decision. Ruled that it had no jurisdiction to intervene, and once the men left Kentucky, Kentucky's law controlled, and their legal status was controlled by what their status was in Kentucky. Fortunately, the court in some years later realized the error in Scott, and that issue was then reversed. And the court does do that on occasion. There's been several primary cases where the court reversed its decision. Buchanan versus Warley. This is a case that's kind of near and dear to my heart. I live literally within a stone's throw of where this house was. A few years ago, we managed to get a historical marker placed for this one. I was really pleased with that. Worked with Sheriff Brian Hamilton, who was excited to get involved in the project and get a marker at that location. This one's interesting because in 1914, Louisville had an ordinance that restricted the racial makeup of home buyers by block. Basically, if a block was predominantly white homeowners, then only a white homeowner could buy in that block. If the block was predominantly black homeowners, then only a black homeowner could actually live there, with the idea being is that you would eventually have these separate set blocks. Buchanan, who was the seller, sold his property to William Warley, who was a ranking member of the local NAACP. I find it interesting when you read the decision because one of the dissenting justices effectively commented that it seemed like this was a setup to come to the Supreme Court. I have absolutely no doubt that it was a setup to go to the U.S. Supreme Court, because taking a case of this nature to the Supreme Court requires you to have a committed plaintiff. You've got to have somebody who's going to stay with the case from beginning to end, not take a settlement, not drop out, but is going to really go the distance. And this was very clearly set up by the way that the contract was arranged. The contract with Warley buying the property said Warley would only buy the property if he could live in the house. By the ordinance, he couldn't live in the house because the block was predominantly white. That set up Buchanan, who was the other member of the contract, the other party to the contract, to then sue him over the contract. Ultimately, it went to the U.S. Supreme Court, and the U.S. Supreme Court ruled in favor of Buchanan. I always like to look at the date on this because this was such an old case, and we forget that these cases were being discussed long before the 40s and 50s, when so many of these cases really came forward. It's just a fascinating case to me. When I realized and started learning about it and how close it was, I couldn't let that one go. I was really pleased to get an actual marker there for that one. They did agree that it exceeded what's called the police powers of Louisville at that time in creating an ordinance of that nature. Obviously, had a lot of fights that had to come later, but this was one of the first where were not proper and not constitutional. The First Amendment. We got some interesting First Amendment cases that came out of Louisville that I got a kick out of. I think everybody's going to know about Carl and Ann Braden. They're very famous, obviously, in Louisville. Carl Braden, he barely missed going to the Supreme Court in an earlier case. He only missed it because a case that was being ruled on at about the same time was ruled in such a way that his case was mooted, became a moot point. So he did not end up going to the Supreme Court in the earlier case. In this particular situation, he was called before a subcommittee for the un-American activities. They were investigating communist activities of which the Bradens were believed to be involved. He refused to answer the questions put to him by Congress, claimed that the questions were not pertinent, and violated his First Amendment right to freedom of association. He was criminally charged, he was indicted, and he was convicted of that, at which point he went before the U.S. Supreme Court and argued that these questions, and these are the questions he was specifically asked, did you participate in a meeting here at that time? That would have reflected, obviously, a time and date and potentially people he may have met with. Who solicited the quarters to be made available, which was where the meeting was held. So they were trying to link up someone who made the arrangements for the location. Are you connected with the Emergency Civil Liberties Committee? That would be a yes or no answer that he did not wish to answer. They also asked about developing plans and strategies and work schedules. This would have linked him with Harvey O'Connor, who was involved with it as well, that they knew of. He also refused to answer questions. Are you a member of the Communist Party the instant you affixed your signature to that letter? And whether being a resident, he had anything to do with the Southern newsletter, which was connected. He refused to answer those questions. Supreme Court did agree in his case that the questions were pertinent to the issue and that his refusal to answer was deliberate and intentional. His conviction was upheld. He was sentenced to a year in prison, but he was released after 9 months after Dr. Martin Luther King became involved and made a plea for clemency. I like these pictures. The booking photos are actually from the earlier case that he was involved with, which I think everyone's familiar with the bombing of the house in Shively in the 1950s. Also see Carl and Ann Braden, who again I just actually drove by their house yesterday, and I hadn't driven down that road for a while and forgot that the marker was there. So I had to stop and pay a visit to that marker. Shapero, everybody here should remember Robert Shapero. What I always laugh about now is that there is also a famous attorney on the national level who has a name with only one letter different that often comes up if you don't spell this one correctly. Robert Shapero was, I think everybody of any age is going to remember his advertisements. The Kentucky Bar Association at that time would not allow him to send what were truthful and non-deceptive targeted solicitation. If you had a wreck, you were probably going to get a letter from Robert Shapero asking if you wished to sue. If you were arrested for DUI, you might get a letter asking if you needed representation. And these letters were very truthful. You know, hey, I would like to represent you. Here's what I might be able to do for you. When they refused, he took it all the way up to the U.S. Supreme Court, and the U.S. Supreme Court agreed that the KBA's refusal violated his First Amendment rights. Commercial speech could only be restricted if there was a substantial government interest, and it found no such interest in the letter that he proposed to send. As a result of this, I think everybody remembers seeing these advertisements. Supreme Court did note that if the KBA was that concerned about it, they could review and rule individually on solicitations, but they could not just say no one can send such solicitations. Attorneys are now governed by a Kentucky Supreme Court rule, which outlines how such advertising will be considered by the Supreme Court. And it's pretty lenient. They've done a good job on not being overly burdensome on such letters. Branzburg. In 1969, the Courier-Journal had a reporter named Paul Branzburg. He was the bylined reporter on an article that talked about his direct observations, and that's what's really important in this case, is that he watched two individuals synthesize hashish. Everybody might remember hashish. You don't hear about it too much anymore, that they then sold. Of course, the Commonwealth learned about this, and he received a grand jury subpoena to appear before the grand jury and identify those individuals by name. He appealed under what is called the Reporter's Privilege Statute, which does still exist, and the state court rejected his argument, mainly because, as I said, he directly saw this. I mean, he was a witness to it. He didn't hear about it from someone else. He actually saw it. He appealed that decision. The Kentucky Court of Appeals, which at that time was the highest court, we did not get the Kentucky Supreme Court till a few years later, also denied the claim. He published a second story in 1971 about drug trafficking in Frankfurt and was again ordered to appear before the grand jury. Now, keep in mind, he's not yet spent any time in jail for any of this. Went all the way to the Supreme Court, which ruled that it was legal to require him to testify about criminal activities that he had personally witnessed. As a result of this, reporter privilege has been shaped a little bit but it will depend upon whether the information was critical to the case and could not be obtained elsewhere, which of course in the case that he was involved in was in fact going to be the situation. By the time the Supreme Court ruled, however, he had left Kentucky and was working in Michigan for the Detroit Free Press. They did sentence him for contempt, and Kentucky, Governor Wendell Ford, requested the Michigan governor to send him back to Kentucky to stand before the courts in Kentucky, and the Michigan governor said no. As long as Branzburg stayed out of Kentucky, he was a free man. If he ever came to Kentucky, theoretically, he could have been taken into custody for failure to appear for the contempt court. To my knowledge, he never came back to Kentucky. He was smart enough to say that he kind of took to the heels and never came back. A little bit of crime and criminal procedure. This is one that a lot of folks are familiar with. Attorneys are familiar with it, obviously, and there is indeed a marker in front of the Hall of Justice there at 6th and Jefferson on this particular one. James Batson stood trial in 1984 before an all-white jury, not once, but twice. The second time around, he's like, there's something going on here. The prosecutor did, in fact, and this was never denied, deliberately removed all Black potential jury members using what are called peremptory strikes. Prosecutors and defense attorneys get peremptory strikes, which are just kind of just because we don't want this person on the jury strikes, as opposed to for cause, where you can say this individual likely has a very specific reason. For example, you probably would not have a police officer sitting on a criminal case because they would be inclined to find with the officer in that case. So there's two different kinds of strikes. In the second trial, because at that point he was a persistent felon, he got 20 years. He argued that by removing all of his peers from the jury, it violated his rights. That conviction his conviction was upheld through the Kentucky courts, but finally in 1985, following year, the Supreme Court agreed to review his case. It agreed that when a particular category of potential juries is eliminated, it undermines public confidence. Using the 14th Amendment, which is equal protection, the court agreed that excluding individuals of the defendant's race deliberately violated the guarantee of equal protection under the law. In a final twist, however, they had found in his favor, obviously, but that would have meant that he would have faced a retrial. He ended up pleading guilty to the original crime with an agreed upon lesser sentence. I think he served just a couple of years at that point. Drawing, by the way, is from a series of articles that the Courier did. I think it was probably about mid-1990s about important cases in Kentucky, and I like that particular drawing. Right after Batson's case, we had another case out of Jefferson County. It was just coincidentally that both of them were out of Jefferson County, and both of them were the same prosecutor on exactly the same issue. The reason this one was accepted by the court was because Griffith, again, almost identical situation to Batson, had been tried by an all-white jury that became all-white because Joseph Gutman, who is the prosecutor, had removed all the Black jurors. That was, again, what all prosecutors in similar situations were doing. The question for Griffith was, okay, now that you've decided Batson, I've already been convicted too. What are you going to do with my case when I can show that it was the same situation? The court in Griffith agreed that it was creating a new rule, and that's a big deal in the court to create a new rule, and that it would be applied retroactively to all the cases across the United States, state and federal, which are pending on direct review, which Griffith's was, or that are otherwise not yet final. And it was not going to make an exception that this was a brand new rule. That meant Griffith, of course, won his case at that point as well. I can remember this was just a year or two before I started law school, that this case was resulting in a lot of cases throughout the United States being overturned. When a situation like this occurs, there's that cascading effect going down to all of those cases that are currently still in direct review, which is a legal term. Basically, they're still appealing their cases. Griffith was released. This is my personal favorite case. I love this case. I would love to have met Mr. Thompson, but I apologize, I got a wrong date on here. It was actually 1957. I apologize. I've worked these slides so many times that I got some wrong dates worked in on them. But Sam Thompson stopped in at the Liberty Inn Cafe, which is in 300 block of East Liberty. For the record, that's where I-65 comes over now. So obviously the building's gone. He's waiting for the bus. He walks in, drops a coin in the jukebox. And of course, if the music's playing, what are you going to do? You're going to dance a little bit. Two passing officers realized he had not purchased anything, which he hadn't, and accused him of dancing in a place that didn't have a license. The bar manager actually later said he didn't care that Thompson was in there dancing. He didn't care that he hadn't purchased anything, but he was cited for loitering. And when he protested, a charge of disorderly conduct was added, and he actually did go to jail. The fine was $10. Thompson, who admittedly did not have a uncheckered past, decided this was the last straw and he was going to dispute it. And he found a lawyer who was willing to take the case. There's Sam right there, and there's the drawing from that same series that I mentioned. The Louisville Police Court judge just doubled his fine. Said, no, you're going to pay $20 now. Well, the ACLU got involved, and Lusky appealed this case directly to the U.S. Supreme Court. What's unusual in that is usually you got to go through a couple of steps before you make it to the Supreme Court. In this case, however, Kentucky had no way for him to appeal it in Kentucky because it was a police court fine. There was no way, the law at that time did not allow for appeals. Lusky argued that Thompson committed no crime and that if lingering in a cafe while waiting for a bus to keep warm was illegal, half the population of Louisville would be criminals. The court agreed and noted that people loitered in businesses all the time. And of course, simply arguing with an officer was not unlawful, or if it didn't lead to further disorder, which in this case it didn't. In fact, that is the standard law now, that you can argue with the police all you want. That is not illegal. I have to teach that regularly in a class that I teach to officers, that if somebody wants to argue with you, it is perfectly legal for them to do so. The court sent it back to the trial court. Back before that same police court judge, Sam Thompson's conviction was dismissed. Unfortunately, he did have an active warrant, so he ended up going to jail for his other warrant. But he did win his case, and apparently was bought many drinks through the remainder of his life based on this. This is a case that I really like because it generates what's called the void for vagueness rule, which is you cannot charge somebody with a crime that is so vague, nobody would realize they were actually breaking the law by doing it. So you hear that void for vagueness on a regular basis when new laws are attempted to be passed. And they all go back to this gentleman, who we all call Shuffling Sam, because that was how it was described, that he was kind of shuffling his feet while he was standing there at the bar. The city did repeal the underlying law that required people to account for themselves, which was what they were basing the charge on. And the state has in fact changed the law that you can appeal such minor cases to the state court. I think Louisville didn't want to get dragged up to the Supreme Court again, so they figured they better change the law. He did continue to be arrested for a variety of minor crimes. He passed away in 1972. I actually tried to find his grave site, and from what I can tell, his body was donated to the medical school. for medical investigation. So I don't know if his family did that or if it was taken to by the medical school because no one claimed his body. I couldn't determine that. Buchanan versus Kentucky. It's kind of sort of in the news right now. If you've seen that Kevin Stanford has been asked to, for parole. So this case is back before the court right now, which is why I wanted to pick this one. Buchanan and his co-defendant, Kevin Stanford, were charged in a 1981 murder case. Bearable Poole, some name may ring a bell with some folks because she had such an unusual first name. At the time, both of these men were juveniles. The co-defendant was charged with capital murder, but Buchanan was actually not charged with capital murder, but they were tried jointly and the jury had to be death qualified because of the charges against Stanford. Buchanan asked that they not be death qualified. If you're not familiar with what that means, it means you have to carefully select a jury, all of whom are willing to at least consider the death penalty. Doesn't mean that they will rule for the death penalty, but you cannot have someone on a jury in a capital case that is themselves adamantly against the death penalty completely. They have to at least be willing to consider it, and that's what the term death qualified means. He asked that the guilt phase jury, the ones that would have actually been trying the case, not be death qualified, with the understanding that the sentencing jury, and those are two different juries in this kind of case, would be separate and would be death qualified. The Supreme Court ruled in this case that a death qualified jury was not inappropriate. Of course, he himself was not subject to the death penalty. Kevin Stanford was. And again, that's going forward, that because Stanford was a juvenile and because of changes in juvenile sentencing, he is no longer subject to the death penalty as well. And again, is apparently seeking parole now. Railroads. I know it seems kind of weird to talk about railroads, but Louisville is a transportation city. Because of our geographical location, we've got bridges, we've got railroads coming from all different directions, and we do in fact have quite a few different railroads that meet here. My own family is a railroad family, the old Kentucky and Indiana Terminal Railroad, the old K&I Railroad. Just about all the men in my dad's generation worked for the K&I, except for the one who went over and worked for the L&N. We're not sure how that happened, but the Louisville Bridge Company built a bridge, which you all see on a regular basis if you go down 64. It's known as the 14th Street Bridge. Sometimes you'll hear it be called the Penn Central Bridge. It was approved in 1865 by Congress because we needed a bridge, because we needed that passageway between the North and the South. And it was completed in 1870. At that time, it met all the requirements. It was a perfectly fine bridge. In due course, as we now know, if you look at the Sherman-Minton Bridge, which is getting worked on, bridges have to be renewed. So of course they sought the necessary approvals. Unfortunately, the law had changed in between. In 1899, new criteria had come out, and the Secretary of War said that the bridge now constituted an obstruction to Ohio River traffic, because at one point in the bridge, there wasn't enough horizontal clearance over the span. And because the span that's over the canal, which currently goes up and down, if you recall, at that time it swung. It actually was like a big door and swung, and it wasn't wide enough. So now you've got a bridge that doesn't meet the rules and needs to be worked on. What do? The bridge company argued that that authorization they had in 1865 was forever. Supreme Court disagreed, found that the 1899 Act, which was lawful, meant that they had to follow and meet the new criteria, which is why, if you go by there now, you will notice that it does go up and down as opposed to swinging. And one pier has been removed. I did not actually realize that and made a point of driving by and glancing over, and it is very clear that one of the piers was removed. You don't see the remains of it, but you know the spacing is off, and clearly they did remove a pier in order to keep that bridge operational. I'm hoping they had an engineer involved in that process before they removed the pier, but obviously it's stood since then, so they must have done it right. We also have this one, which I laugh about. Only in the law can we argue about whether an engine and 26 cars constitute a train. They were being moved between two train yards, and the train in question was 1,100 feet long. So the engine and 26 cars were 1,100 feet long. They were going to be traveling 3/4 of a mile, crossing 3 city streets at grade, 2 city streets twice, 1 street 3 times, and there was going to be a main track movement of 2,600 feet. Why was this a problem? Because they didn't want to hook the brakes up. And they did not want the brakes to be coupled so that the engine could control the brakes of all those 26 cars as would normally be expected. Federal safety law required the brakes. The owners of the train yards in question didn't want to hook up the brakes. I'm sure it was a bit of a hassle to do when they were simply moving them between 2 yards, but fortunately they lost. Louisville and Nashville Railroad versus Mottley. I love the Mottleys. Erasmus and Annie Mottley was involved in an accident involved the L&N Railroad. Apparently it took place out where the tracks run along Preston. If you're familiar with what was called the Big Pond, that marshy area out of Preston, it apparently occurred in that area. As a result of this accident, they got free passes. That was the settlement that they agreed to, that they would forever be able to travel free on the L&N Railroad. They every year had to renew their passes, but that they would be able to travel free. Decades later, the passes were declared unlawful under federal law, totally unrelated to the Mottley case. It was a federal law that applied to all such free passes. So the next time they tried to renew the pass, the railroad no longer renewed it. They said no. The Mottleys wanted their passes, so they sued, went all the way to the Supreme Court. The court ruled that this case was invalid due to a lack of subject matter jurisdiction. Having gone through law school, you get your brains beat in daily by the issue of subject matter jurisdiction. Does this court have jurisdiction over this case? Even though this was a federal law in question, the court agreed there was no federal question and there was no what is called diversity of citizenship, because the Mottleys were based in Kentucky and the L&N was based in Kentucky. So it was a Kentucky problem. The Supreme Court sent it back. They went back to state court. Kentucky ruled in their favor, ordered the railroad to give them the passes. The railroad appealed. It ended up back before the Supreme Court, which meant that we now have a case a couple of years later. They didn't do any better the second time around. The Supreme Court in that piece of the case said that the act of Congress, which made the passes invalid, was itself valid. As a result, the Mottleys no longer got to travel for free. Given the time frame, I don't know the ages of the individuals involved, so I don't know how much future travel they planned after that, but whatever they had to do, they were going to have to pay for. Odds and ends. Everybody remember Arlen's? I remember shopping at Arlen's. It was a department store that many of us were familiar with. This goes back to the blue laws. 3 Louisville Arlen stores were fined $20 in cost because they had people working in their stores on Sunday, which was a violation of Kentucky's Sunday closing laws. Court ruled that, again, there's no substantial federal question. In other words, it was a Kentucky issue, not a federal issue. I find that interesting. They, as a result of that, by the way, they very soon after that got rid of Sunday laws. And of course, most places now, other than for alcohol, there really isn't any restriction on working on Sundays. We still have that kind of hanger on when it comes to alcohol laws. And finally, Clay versus U.S., 1971. In 1967, Cassius Clay received his draft notice. He didn't want to go to Vietnam. He claimed conscientious objector status. He went through the proper process. He did everything that you were supposed to do when you were going to claim conscientious objector status. The hearing officer with the Department of Justice, in fact, even ruled that his claim was sincere. He went through a hearing. He talked about his religious beliefs. He talked about why he did not believe in fighting in that type of a war. But the DOJ advised the appeal board to deny his status, and he was ordered to report for induction. He refused. As we know what Cassius Clay was doing during that period of time, this was obviously national news. He was prosecuted and he was convicted. He did not spend any time in jail, however. He was stripped of his titles at the time and banned from boxing, but did not serve time. He appealed, arguing his status should be respected. Went before the Supreme Court. The Supreme Court noted that the appeal board never put in writing what the problem was with his petition. There were particular tenets that had to be met if someone was going to be claiming conscientious objector status. In his case, it's a matter of, is this a valid religious objection? Are you an actual participant and a congregant of this particular religion? Did it all add up is what it really came down to. Because the appeal board did not put it in writing, the Supreme Court had nothing to work with, so they reversed his conviction. And of course, we all know that that's Muhammad Ali. He said he did not serve any time. And as a result, it continues. I mean, I've actually have not read the book. This is actually a book that you see up here. And after reading about this, I want to go back and read the book and learn more about the legal proceedings in the case. In conclusion, undoubtedly, we're going to be before the Supreme Court again. Kentucky's had any number of cases before the U.S. Supreme Court, including one that will be heard this term that is being argued by the Attorney General's office, the Kentucky Attorney General's office. There are some fascinating cases out of Kentucky, so I may be doing something similar about those cases in the future. Little slide for those that are watching this. Please feel free to check out the YouTube channel as well as the League's website. And that's the end. Hope you guys enjoyed it.
Great. Thank you.
You learned something.
Thank you, Shawn.
Yeah.
And if anyone wants to ask a question, please take you off of mute there and ask a question.
I apologize for the few little errors on the slides. I was bouncing this slide set back and forth so many times that I lost track of them.
It's okay. I understand. Again, I think anyone that wants to talk will have to take themselves off of mute.
I have a question, actually two questions.
Yeah.
First of all, I'm wondering, in the case of Shufflin' Sam Thompson, what happened to the police officers?
Nothing. I mean, they did not violate any law by what they did. And that actually, I'm glad you brought that up because that's a good issue that comes up in some of these cases. At the time they made the charges, that was considered to be a valid charge under the law. And in cases of this nature, usually what the court will say, okay, you're fine. You did what you understood the law to be at the time. But from this day forward, everybody listen up. Don't do that again. We see a lot of cases like that, especially in law enforcement law, because they don't expect the officers to second guess or be constitutional scholars to know that there's going to be a problem with what they are doing. And that law was it was in fact very vague. If you read the current disorderly conduct statute or ordinance, not the statute, but the ordinance, it's really long and it lists all kinds of very specific things that you're not allowed to do to get away from that void for vagueness that was part of the ordinance before.
Yeah, I know that it was at one time illegal to have an ice cream cone in your pocket.
Not in Kentucky. That was probably an ordinance somewhere. I've never been able to track down where. There are some interesting statutes that are still on the books in Kentucky. You know, you actually aren't allowed to duel. You're not allowed to handle snakes. These are actual criminal statutes that are still in the law. Unlike what my mother always told me, you can, however, drive barefoot. She always told me that was against the law, but there's no law that says you can't drive barefoot.
Second question about the very low penalties, especially for Arlen's department store. That just strikes me as very strange.
Well, I mean, we're also talking about that would have probably been maybe roughly $100 to $150 fine, and they were, because of the nature of the way these rules were set, they generally did have extremely low fines. But again, we're talking 100, 150 probably is what the equivalent would be now. Same thing for looking at Sam's penalty, which was $10. That would have been a nice sum of money in 1960. You know, probably again 100, 150 roughly. So it would have been a substantial. We laugh at 10 now, but that would have been a substantial bit of money for someone who I'm quite sure was not wealthy to have had a fine of that nature.
Yeah. Thank you for your presentation. This has been quite interesting.
Do we have any other questions? I don't see anyone taking themselves off of mute. You'll again take yourself off mute if you need to ask a question. Well, evidently, Shawn, you covered all the bases from what I gather.
I tried. I apologize for a couple little typos there. I was living this presentation for a few days, and like anything, when you look at it too many times, things creep in on you.
Totally understand. Well, again, our next meeting is going to be Sunday, December